My dad made me the executor of his will. Upon his passing, am I automatically the executor? No, you are not. You ultimately need the official paperwork from the court. What has to happen before that? Well, the court has to look at the original will. They have to verify information. They need to receive a petition. The petition's the application. Hey, I'd like to be the executor based on the will. And the court reviews. The court makes a decision. The court ultimately issues letters testamentary. That's the official paperwork from the court. Then and only then do you become the executor. Don't make the mistake of accessing a bank account or trying to spend the money. It's not good. It's not allowed. It's inappropriate. Only work with the official court documents. The client came to me to probate a will. Client only had a copy of the will. We could not locate an original will. So instead, we're doing an administration of the estate. The copy of the will cannot be probated. So the proceeding is that a beneficiary under the will is asking for me to be examined under oath because the assertion is, from this person, is that I have the original will. I was not the attorney draftsman. I never had the original will. My client never had the original will. So I guess there'll be questions like, do you have the original will? I'll say no. Have you ever had the original will? I'll say no. Did you draft the will? I'll say no. Did there come a time that you ever had possession of the will? I'll say no. Maybe it'd be a little bit more than that, but there's an awful lot I don't know. I don't know where the original will is. So that's the type of proceeding. It makes sense to ask. And really, right, because someone could potentially get a will that they're not a beneficiary under and rip it up, destroy it. Committing a fraud, it's a crime, right? They destroying someone else's will. But maybe, you know, the adult child doesn't want to have the stepmother receive anything, or maybe the half-sibling. I can envision a few terrible scenarios, but in this instance, I never had the original will. So. I had a surrogates court conference today. The surrogates court is still utilizing the Teams system. Looks very much like a Zoom. You're on screen. Attorneys were present, clients were present. And the content of the conversation, this was an administration proceeding. An administration proceeding is where there's no original will. But there is a copy of a will that all sides have. The issue is, where is the original? Could be that the original was lost, misplaced, destroyed, gotten rid of by the person that prepared the will. Now, and that's a scenario that takes place all the time, right? Consideration. If you have a copy, what do? Can you probate a copy of a will? Well, only really under very limited circumstances, fire, flood, things like that. Otherwise, the law says there is a presumption, if you don't have the original, that the will was discarded, thrown out, destroyed. This particular will is like, how old is it? It's like 30 years old. So there's a lot of time between the creation of the will until now, when the decedent passed away, and the will was lost in time. But part of this conversation was, let's go back to the attorney draftsman, and that person has since passed away, but when that person's passed away or retired, was the office taken over by someone else? Were the records and files taken over by another attorney. Was the will ever filed in court? So those are some of the questions that we have. I was presented with a situation today. It was by a colleague that was confronted with a situation, a friend of a friend, and asked me for advice. I figured I would answer here publicly. I did give my friend the information. So I didn't say, tune in tonight. I did think that it would be a good question. The scenario is a person had been divorced with children, and then they remarried. This person remarried, has been remarried for 5 years, and just passed away. No will. Could this be a case of unintentional disinheritance? Well, partially. When you have a blended family, when you have a second marriage, you really do need a will or an estate plan so that you can protect the legacy, the financial assets of the family, have money go the way you want it to, protect your children from a prior marriage. In this instance, because there is no will, and they owned a property and had some money in the bank, the spouse will receive under the laws of intestacy. So there'll be an administration proceeding. The spouse, the surviving spouse, will receive the first $50,000 and 50% of the balance. So if there was a bank account with $51,000, the surviving spouse would take $50,000 of it, and the remaining $1,000 plus any additional funds and the property would be subject to this 50% additional intestate share for the surviving spouse. The children would receive the balance. So 50% between children and spouse, with the spouse also getting the first $50,000. So mathematically, if the scenario was different, and I'll go back to my $51,000 bank account. If the $51,000 bank account was the total estate value, the spouse would be entitled to the first $50,000, and the next $1,000 of the 51 would be split 50-50. So in that scenario, the spouse would receive $50,500, and the children would split $500. So if there were 5 children, they each get $100. And that's why you need a will. And if you need a will, please reach out to me. I was preparing a couple of wills today for different clients, and as part of the drafting process, but I wanted to give you a couple of takeaways from both of them. So I have a parent, a single parent, with 2 children. I don't know how much I want to share. A single parent with 2 children. And the parent has some money and 2 pieces of property. During the life, this person's life, this parent had given some money and some assistance to one of the children. And the way this parent wants to make up for it is that I'm going to use 123 Main Street. You get what that means, right? So the way we have orchestrated the will, and it is a will now. Right now, there is no plan in place, no estate plan in place. And we at least need a plan because this parent would like to make even some of the money that had previously been given to the other child, to one of the two children. So the property in question, the way we're going to take care of it is the property located at 123 Main Street will go to my child A. Everything else that I have will be divided equally between A and B. Now, if you don't need to, how am I saying this? A will is required when you want to leave things unevenly, not equally. So this person, a widowed parent, has 2 adult children. If this parent did not want to leave assets unevenly, there may not be a need for a will. Upon the death of this person, any assets could be bequeathed to the children by the laws of intestacy. Things will be split evenly. The will, a trust is even better, but the parent wanted to do this now, just in case a trust doesn't ever get drafted or consented to or agreed to. Still thinking about it. But at the very least, this last will and testament will preserve the asset for one specific child, making up for a lifetime of gifts to the other child, and that's how we resolve it. Okay? I got lost in thought along the way, but I think you guys, I think it's understandable. I received notification today that we were put on alert that my office and a client of mine is going to receive a motion to compel, a petition to compel the production of an original will. We don't have it. We don't have the will. We don't have the original will anyway. The circumstances are that a client came to my office with a copy of a will. They did not have an original will, and they asked if we could probate it. The circumstances led us to make the professional opinion that we could not probate the copy of the will in this instance. So we are putting forth an administration. An administration is an analogous legal proceeding, legal situation in the surrogate's court, where you are administering the assets of a deceased person and you don't have a will, that there is no will. One of the family members that believes that they're in a better position financially to inherit under the will rather than without the will has asked that we, more than asked, they're seeking to have us compelled to produce the original will. That's what we wanted to do in the first place, but we don't have it. We were only provided a copy, and our client only has a copy of the will. We don't know where the original will is. When an original will cannot be produced, the presumption is that the original will was destroyed. Not by the holder of the copy, but by the person, right, the drafter of the will, not the drafter, the actual person that is making the will, right? So in this instance, it's the decedent. But the person that made the will, the presumption is that they were dissatisfied with the will at some point and ripped it up, destroyed it, threw it out, and that the copies just remained. So I'll let you know how this goes, but we do not have an original to file. please keep your will in a safe location. In a corollary, today I oversaw the signing of an original will. Right? So the signing of a will, and once you sign it, it's original. But the client asked, what should I do with this will? And then we had a conversation about what to do with the will and how to safeguard it. And if you need that conversation, please reach out to me. I received the question, can a will give a life estate to a property? So the answer is yes. I'll explain a little bit more. A life estate is where one person is given the authority, the permission to live in a property for all of their life. And then upon their death, the property will go somewhere else. The actual way to create a life estate is through a deed. Say, for example, that I am the owner of a property and I want, who should I use? I want my adult child to be able to remain in the home after my death for all of their life. I can, in present day, change the deed. I'll give a different example. I own a property outright, and I want to stay in the property all of my life, and then upon my death, give it to my adult child. So I would create a new deed with the name of the person that I want to get the property, and in the deed I would reserve for myself a life estate. I had confused myself. That's one way to create a life estate. It's on the deed, the presently existing deed, and the person that resides in the home keeps the life estate, and then the property transfers to the next person upon the death of the person that has the life estate. The question was, I am on a deed, I own the property, no one has a life estate. Can I, in my will, say, upon my death, I want this next person to have a life estate, and then after that person passes away, I want the property to go to someone else? Yes, it is possible. So in that example, I use letters, I guess, X and Y. So this would be the will of Frank Bruno. That's me. And I would say, upon my death, I give to X the ability to stay in the property located at 123 Street. I permit X to remain there for all of their life, or for as long as they choose, X chooses. And then, upon the death of X, I want the property to go to Y. That is completely possible. I talked myself in and out of a situation on this video, but it is possible. It can be done. I have done it. And in writing, it looks very smooth. If you would like me to write something for you, a will, a trust, an estate plan, a guardianship petition, a new deed, my office can do it. We can do it together. Stay safe and be well. FrankBrunoLaw.com.